I actually asked Prudence to come to the Kempe conference because one Friday evening, when I think no one else was in my house, because I have fairly well launched my children, I was sitting on the couch and I decided to read the ABA Resolution 606. And I thought, if we're all about changing child welfare, we have to understand this story. And so it's just I'm very appreciative, as is my other colleagues at the Kempe Center, that the ABA is willing to share this knowledge with our international learning community. So without further ado, I will turn off my camera, put myself on mute, and welcome our panelists. And I think we'll turn it to Brenda.
Good morning, afternoon. I think since this is international, we're at various times here. I'm in Los Angeles and it is 1 o'clock in the afternoon. So hello, my name is Brenda Robinson. I am an attorney for Children's Law Center, and I've been practicing in dependency for about 24 years. I've been with Children's Law Center for about 22 of those years. And I'm also the chair of the Commission on Youth at Risk, which is a part of the Center on Children and the Law. And my colleagues today, I'll get to those in a second, but I do want to talk about why we're here. We're here to talk to you about the resolution that our committee worked on for 2 years and ultimately was passed by the House of Delegates on really it's a racism within the child welfare system. So we're going to talk about the resolution, why we passed it. We're going to focus on the historical roots. And that's the portion that we want you to be the most engaged in. You don't need to listen to me right now, but we really want you to be engaged in the historical roots, some of the obstacles we faced, and the ending will be up to you. The resolution really calls you to do something. And that's why we really want you to stay engaged, because this is going to be some difficult material. Prudence, next slide. So as I indicated, my name is Brenda Robinson, and we also have Lakeisha Dorsey, who is also a commission member. She is a former parent attorney with a law firm that just represents parents in Los Angeles. She branched down on her own. She has a very full practice, and part of her work is to continue to represent parents on a pro bono basis who find themselves in the dependency system. And then, of course, we have our illustrious leader, Prudence Bettler-Carr. She is the director of the Center on Children and the Law. She oversees the commission. She does a phenomenal job. She's a mother, a wife, and yet she is almost at our beck and call. So I'm going to pass it on to Prudence. She can tell you a little bit about the center and what we do, and then I'll take it from there.
Thank you, Brenda. I was laughing when Lisa said she has well-launched children. I am getting texts right now about various childcare pickups, so to really ground us all. I wanted to just orient everyone with this slide because I know a lot of you on the screen have worked with the ABA Center on Children and the Law before, but some have not. And so I just wanted to give sort of a little bit of background. Thank you, Lisa, for doing the mute. A little bit of a background about what we are. So we are an organization that exists within the very large American Bar Association. The larger ABA is a trade association of lawyers and judges that's comprised of about 300,000 members and who work in all different areas of the legal system. So in business law, in torts, in tax law, environmental, international. And within that, the Center on Children and the Law is essentially a nonprofit that does a lot of grant work across the country, primarily focused on improving the child welfare, the work of the legal system that affects child welfare. We work closely with parents, attorneys, children's attorneys, agency counsel, judges, and courts. And we also, as sort of a bridge to that larger member association, we have this amazing body of members who are appointed by the ABA president every year, including Brenda as chair and Keisha Dorsey as one of our members. And during the period when we were developing this resolution that we're going to talk about today, Judge Ernestine Gray was the chair as well. And so we've had a really great benefit of working with members who are appointed by the ABA president to sort of help set the ABA's national policy agenda on child and youth law topics. And the reason I wanted to frame sort of how we are structured within this larger association is to underscore that the resolution we're going to talk about today was passed by the entire association. So represents something that the center and the commission put forward to the association, but was voted on and supported by that 300,000 body of ABA members who represent tax and international, and really got behind the messages in this resolution that you're going to hear about. Brenda, I will pass it back to you. But you are on mute.
Thank you. Lisa, as she mentioned, one late Friday night, I love that. Her wonderful late night reading was the ABA Resolution 606. And this, if we were in person, we would be handing you copies of this, but you have it on the screen, but also these slides that we've provided or have been provided to you as well. And I really would encourage you to read the resolution in its entirety. The significance of this, most of all, is that there was so much support from throughout the whole ABA in this resolution. So when it went to the House of Delegates, the fact that the focus was on racism within child welfare, and that the House of Delegates was willing to take on this very controversial subject, as you'll hear about later, is very important. Next slide, please. And so there's a connection here. We also, before passing 606, we had worked diligently on Resolution 613. And I'll tell you a little bit more later, but we developed both of these with the idea that Black families, there's culture, there's humanity, there's just so much richness within the culture that we felt was being lost in the whole separation of families. And so originally I spoke to Prudence about, we were just focused on getting kids to court. And I'm sorry, did something just happen, Prudence?
No, you're doing great.
Oh, okay. My screen just went blank, so I'm sorry. So there was a conversation about getting children to court. Process of us talking about that, the heritage, the culture, and different things, we realized that we really did have two separate resolutions. We had a resolution on how important it was and the presumption of children getting to court, which is our 613, and then in 606 in addressing the racism within child welfare system. And so from there, and I apologize, I seem to have all of a sudden have a glitch where I can't see anyone or anything or the slides. So I
think we can still see them.
We can still see you and hear you.
And you can still see and hear me.
Mm-hmm.
Well, quite sure what happened, but I'm going to keep on rolling.
You know this stuff, Brenda. You've got it. I'll cover the next slide, but you're good.
Hi, Prudence. Thank you. So you can go to the next slide, Prudence. And so Resolution 606, once you look at it, really does call for there to be really an obliteration of racism within the child welfare system. And you're going to see that it really does stem from the history of slavery in the United States. And it comes from the over surveillance and underinvestment in Black families. And as we learned the history ourselves as a commission, we realized that it was absolutely necessary, not just to call ourselves to this, but to call the whole legal profession to learn about this and to change their practice. And that includes the attorneys, judges, and the professionals who are in these families' lives. Next slide. And
Great.
Prudence, give it to you.
I'll take this part. So before we get into, as Brenda's alluded to, a lot of the bulk of today's session is going to talk about the history that we really tried to explore. And I wanted to frame that as there's a lot of different analyses of history and how child welfare has developed over the years and how issues of racism in child welfare have developed. And I want to sort of anchor this discussion in a couple of key ways. One is to just emphasize we're the ABA. It's an association of lawyers and legal professionals. So our focus on the history was really looking at the way that the law has been structured over time and looking at the way that the law has been structured within certain periods of time where there were a lot of other social factors that affected that. But our sort of focus and emphasis is really on the law and the foundation of how the law has been built in this space. I like this slide to orient us before we dive into the history, because I call this my 2.5 reasons of why we focus on the historical roots. The first is this Desmond Tutu quote, which is, we learn from history that we don't learn from history. And I want you to sort of remember that quote because we're going to come back to that in a little bit. But it's this sort of truth and reconciliation component that as we, as Brenda described, as a commission, we felt very strongly, starting in 2020, like so many other organizations, felt very strongly about examining these issues with much more depth. But one of the things that I think we were very conscientious about not wanting to do was to just issue a statement or just say, you know, we're going to do better and we're recognizing this in this moment in time, because we have been there and we have seen that. And we really wanted to pause and take stock of learning and owning even the pieces of responsibility that the ABA itself has in the trajectory of what we're going to look at. With that understanding that we can't really have reconciliation, we can't move forward with any of this without understanding where we're coming from, and without wrestling with that. And the commission itself was comprised during this period of time with a lot of diverse perspectives on these issues, a lot of different personal experiences related to some of these issues. And I think one of the most important pieces of that was the way that we were able to create and cultivate a space of exchange to dive pretty deep into this, and reach a point where we as a commission had sort of a unanimous commitment to the things that we put on paper to present to the larger association. So that first, when I say 2.5, and I know some of you are very good with numbers and you're already tracking, you're like, I only see 2 visuals up there. So the first sort of reason why we focus on historical roots is that truth and reconciliation component. The second, and you can look at this however you want, this clip art as, you know, maybe it's construction, maybe it's demolition. But I think the message that we really try to convey is there's a lot of conversations right now about abolition, about tearing things down, about looking at reimagining, transformation, so many different words, right? And I think what we wrestled with in a big way with that was saying, like, okay, no matter what we want to do, we need to understand the foundation upon which this is all built. Like, even if we're going to tear it down, it doesn't work to only tear down, right? Like the addition that was added in 1996, or, right? Like, we've got to really understand what it is that the foundation was laid upon if we're going to understand how to imagine something very different. And so that's sort of this second part, which is really thinking about the structure and that sort of metaphor of this is a building, this is an edifice that was built on a foundation. Let's understand the depth of that foundation. The 0.5 is that, like I've said, we're an association of lawyers and judges. And so we were presenting all this material to lawyers and judges, and we knew pretty clearly that we were not going to succeed in presenting, an opening statement connecting racism in child welfare today with the history of slavery in this country if we didn't make a really solid case for how that all fits together. So that's the point 5, which is that we really wanted to sort of make that case and use the report that accompanies the resolution and that laid some of the groundwork for today's presentation as the sort of making that case. So the rest of this is going to focus on a lot of that case before I pass it back to Brenda and Keisha. So what did we learn? There's 2 sort of overarching themes that come across in the opening line of the resolution itself. And I really want to emphasize this before we go into the segments of history, because a lot of conversation in the children's law space in the US is on issues of surveillance and over surveillance and how families, Black families in particular, have in many different periods of history been surveilled and sort of funneled into punitive systems, child welfare and otherwise. But there's a second piece of the puzzle that you're going to see really mapped out today that's about underinvestment. And I think those are equally damaging in many ways, right? There's a very, very clear over surveillance component to this history, but there's also a really powerful example again and again of deliberate underinvestment to serve other people's interests that also helped shape where we are today. So sort of hold those 2 things in your mind as you follow the next segments. So just going into some of the over surveillance, and I do like to explain, especially when going into this much in a brief period of time, we do have longer versions of this history, and we have sort of longer versions of some of it written. And so please do reach out if you want to have more extensive material, and we can show you other places to look for a lot of other things that people have written in this space. But this is going to be sort of the broad strokes. So when we're looking at that over surveillance theme, obviously in the United States, there is no place for us to start other than the origin, and really recognize that when we're talking about Black family separation in particular, we have to start at the origin of this country and the origin of slavery, which was condoned and legalized very specifically throughout the colonies at the beginning, before we even were a country. And what I want to emphasize here is, I think sometimes there's a message that separation of children from their parents during slavery was incidental to slavery itself, and it is something that was a cost of slavery. But what's really important for us to recognize when sort of grounding ourselves in this foundational understanding is it was not incidental. The concept of removing children from their parents was actually part and parcel of the structure of slavery as it was codified under US law. So as early as the 1660s in Virginia, the law established a system where normally, right, in all other situations in law, we followed the English codes and we implemented a law of paternity that a child would follow from their paternal line under law. But in the colonies, we sort of bucked that trend and decided that if you were born to a mother who was enslaved, no matter who your father was, you would follow the maternal line and you would inherit a status of enslavement from your mother who was enslaved. And so I just want to emphasize how significant that was under law, because not only was slavery, was the threat of family separation often used to further issues like compliance, of telling an enslaved parent that they would run the risk of being separated from their kin, from their children, from their families if they did not comply. But it was also very much an economic structure. So especially after 1808, when the importation of enslaved people was no longer permitted under the Constitution, the whole production of slavery, the whole economic structure of slavery was really dependent on forced pregnancy and taking children from their parents, from their mothers. And I underscored very deliberately this quote that we have from Thomas Jefferson from 1820, who gave this guidance to a fellow plantation owner, that he said, "I consider a woman who brings a child every 2 years as more profitable than the best man on the farm." And just to sort of underscore, this was not incidental. Separation of children from their Black parents was very much part of the economic structure that existed. It was part of the legal structure that existed, and it was very deliberately set up that way. The other thing that I like to emphasize, and it's harder to do this on a Zoom when I can't see all of your interactions and faces, but I like to emphasize this even on the Zoom. I usually do this in a room. part of the challenge that we've had on people saying like, well, why did we have to go so far back? Why do we have to look at these origins and these roots, even if there's a legal system in place that makes sense to look at? It's to recognize the legacy and the significant period of time during which this legal and economic structure created everything that we live with today. And so what I say when I can sort of be with an audience is that my husband and I have known each other since we were 18 years old. And we reached a point, we met our freshman year of college. We reached a point around 37 years old when we realized we had known each other in our lives for longer than we had not known each other. We've long surpassed that point. But I share that to say slavery was condoned under law, supported under law for over 250 years in this country, and it's only been illegal under law for 158. And so when you think about that, we have not known ourselves as a country for nearly as long without slavery as we have with it. And I think that also helps ground why we have to start at this origin story, why we have to start at the beginning. Even after slavery was abolished in 1865, there were quite a few legal structures put in place very quickly after that continued to result in over-surveillance and continued to result in separation of Black children from their parents. And much of that, right, deliberate. And so two of the most dramatic and glaring examples were vagrancy laws that were put in place to criminalize individuals who were unemployed during this period in time, which often meant criminalizing Black women and men, and then putting them into situations that were very much like their prior enslavement in order to have them work without compensation, and often on plantations where they had previously been held. The other laws, and I want to emphasize here that I have bolded quite a few of the words that you're going to see on the subsequent slides. I didn't do that inadvertently, so please do track when you see bolded language. You're like, oh, Prudence is going to come back to that. The reason that I bolded this is because these apprenticeship laws were an early form of legal system that was put in place deliberately for taking care of children, and primarily addressed taking care of young Black children who were living with their parents during Reconstruction and living in impoverished situations. And either the idea was that a child could be apprenticed from the parents and taken from the custody of the parents, and either because there was some reason of poverty that was making the child living condition unsuitable for them to live, or their parent, they had lost their parent either to like the arrest, or some other cause that maybe had resulted in them becoming an orphan. And so these apprenticeship laws actually were using language, and there's language from a judicial decision in Maryland at this time that says it was in a child's best interest, primarily Black children, to be apprenticed from their homes to a former slaveholder. And so they were taught a trade while living with a former slave owner. They were taught a trade that was supposed to be their best interest because it was going to help cultivate their, exit from poverty, but of course was very much akin to the exact same work that they had been doing previously. The other sort of moving to the underinvestment side of things, and again, we're not actually moving that far along in history, right? We were just looking at a couple of decades post during Reconstruction and post-Civil War. And during the early years, even before the Depression began, states started passing something to support children and families called mother's pensions, started providing something called mother's pensions, which were designed to help mothers when there was not a male breadwinner available to support the family. Most of these state level pensions were very exclusionary and only available to mothers who had been previously married, so they were widowed, and almost never provided to anyone who was not white. When the Depression began, there was sort of this not unlike what we saw during the beginning of COVID, this sort of sense of democratizing of what it feels like to be vulnerable and impoverished, and what it feels like to have to navigate the challenges of raising children without resources. And so there was a very big push in 1935 as part of what was called the Second New Deal to take this concept of mothers' pensions and make it much, much bigger and provide financial support to lots of mothers raising children without the support of a male breadwinner, but for a variety of reasons. And so the idea of that support was not limited by, it was not limited only to individuals who are widows. It was supposed to be provided without discrimination in terms of being available to Black families, to Black mothers, to Indigenous. And the program, and it was designed, actually, this Aid to Dependent Children program through the Social Security Act was designed by 2 caseworkers who were at the Children's Bureau at the time. And one of the things that they designed was to recognize that in addition to providing cash stipends for mothers through Aid to Dependent Children, it would be really important to also provide sort of parallel casework services that would help people navigate a lot of the challenges of the Depression, including like access to food banks, access to, support for housing, access to job searching, to really sort of provide that sort of good casework services, and they were going to train lots of women around the country to do that. The idea, as expressed by the Children's Bureau, was to provide this support that was not stigmatizing. So right before ADC was enacted, Congress made several changes, and it's really brutal, actually, looking at this history and realizing kind of what could have been in a lot of different directions. But Congress eliminated the federal oversight role, so that whole idea of this being provided in a non-discriminatory way was dependent on there being federal oversight of the distribution of aid to dependent children. And once that was eliminated, it became very difficult to ensure equal treatment regardless of race and marital status, as had been the plan. Also, the program was transferred from the Children's Bureau, which is where it had been designed, to the Social Security Administration, which really didn't have a lot of focus on children or parents or families. And it became much more sort of less of a thing that anyone was committed to administering once it shifted away from the Children's Bureau. Also, the program was reduced from $120 million annually to a $25 million appropriation. And this is where I really want you to sit with this language, because we're going to come back to this. But the Congress provided in the legislative record that it would be okay for states to limit eligibility of aid to dependent children based on determining which homes were suitable. So they could decide when distributing this funding if a home was worthy of financial support from the federal government and state government. And then also Congress removed a requirement to pay a reasonable subsistence compatible with decency and health. And so states could decide whatever level of support they wanted to provide, and they could do it, adjusting it based on who was the recipient as well. So once enacted, the Aid to Dependent Children program, which most states did take up right away, not every state, but most states did take up right away, allowed state and local officials huge amounts of discretion that had been exactly what wasn't supposed to happen. So states could set eligibility criteria. They could define what it was to be a suitable home, sort of worthy of this support. And remember that caseworker provision that was supposed to come after the provision of financial services to help with all the other things? That got completely flipped. And so caseworkers suddenly became assigned to determine suitability. And so they became the gatekeepers to access rather than the supports on the back end. Also, what we see happening in a lot of states, especially southern states, and again, this is only 70 years after the abolition of slavery, was that entire categories of recipients were excluded from provision of this support. So the most common exclusions were for anyone who worked in the field and anyone who worked as a domestic worker, which are typically positions that were held, obviously, by Black and Indigenous women at that time. And then cancel, the states could and did cancel periods of coverage when low-wage labor was short. So during crop seasons, for example, could cancel coverage entirely for groups of people to encourage return to labor. And so this is a period in time, right, when the concepts of discrimination were starting to be challenged. It's not like there weren't local groups recognizing these problems. And so I sort of raised that question, like, were these exclusions challenged? And the answer is yes, very much. When we see in history that a lot of those challenges got most traction was actually during World War II, when there was a spotlight internationally on the United States, really examining, like, as we were out overseas projecting this, end to Nazism, end to fascism, and that we were sort of the vanguard of democracy. It became very awkward to do that when there were a lot of images of what was happening domestically at home. And so there was a lot of international pressure to provide support to families in a less discriminatory way. And then there were also a lot of organizations like the Urban League and many sort of Black early civil rights movement leaders who challenged these exclusions. And what happened is we saw a big expansion of provision of ADC, aid to dependent children, to Black families during the early 1950s and late 1940s. Okay, so everything's looking good. Then we have a really big watershed moment. And again, when we're in the room, I like to get the show of hands of, who's ever heard of Brown versus Board of Education? Hopefully, even those of you who are calling in internationally, the answer is that you all have. But what I also like to sense is who's ever heard of Brown versus Board of Education in a presentation about the history of child welfare law? And usually it's kind of crickets, right? It's like the tumbleweed passes through the audience at that point, because this isn't a story that we usually tell. And when I have this slide up here, I think the initial reaction is like, oh, watershed moment. This must have been a really good moment in history for where we're going. And I just want to prepare you for the exact opposite. Which is, for those of you who are sort of like, okay, Prudence has talked a lot. We've hit, slavery. We've started in the 1600s. We're now at Brown versus Board of Education. What does Brown have to do with aid to dependent children and child welfare? And this is kind of like, this is a lot to pack in. And the answer that I want you all to leave with, if nothing else, if you don't remember the numbers that we're about to talk with, if you don't remember the next parts of the statutes we're about to talk with, is Brown versus Board and ADC and child welfare have a lot to do with one another. It sort of forms the architecture of the modern day federal child welfare system that we operate under. So in the late 1950s, as school desegregation, right, we had Brown 1 and then we had Brown 2, because Brown 1, of course, did not result in instant integration across the country. As it became the law of the land to integrate schools, a lot of jurisdictions in the North and the South, frankly, needed to figure out ways to fight that. And one of the ways was, remember those suitability laws that determined who was worthy of receiving support? And remember that in the late 1940s and early 1950s, those had substantially expanded and a lot more families were receiving support. So all of a sudden, across the country, state and local jurisdictions passed even more restrictive suitability laws than they had had in the prior decades. And those suitability laws were designed, and there's legislative record that indicates this exactly, where we have a legislator, I believe from Mississippi, who said, right, like with the enactment of this law, we are trying to encourage families to leave our community and move to Chicago. These suitability laws were designed specifically to push Black families out of the community in order to limit school enrollment, because if they had to comply with the law, they could avoid it as long as there weren't members of the community who were integrating. These laws eliminated public support for parents by finding them unsuitable or unfit for public benefits. I want that word to really sit with you, the unfit, because this is sort of the beginning of where we're seeing language that we continue to see in modern day child welfare, but it was unfit for public benefits. It was not unfit to parent. And it was very, very directed at why these fitness determinations were made. Louisiana, which is a really good example because that ended up being another sort of thing that was in the papers and garnered a lot of international attention, was a new suitable home rule cut 23,000 illegitimate children from welfare, from aid and support, the exact same year that Ruby Bridges integrated the public schools. And 95% of those children who were cut were non-white. That Louisiana data is not unique. The impact across the country, like I said, this was not exclusively the South. I'm from Chicago, where some of these things were happening as well. But the impact was extraordinary. In the span of just a couple of years, especially in Louisiana, Michigan, Georgia, Virginia, Mississippi, and Texas, we saw hundreds of thousands of children cut from public aid, almost all of them Black and Indigenous, because their parents were unfit. And all of this happened in the years immediately after Brown versus Board of Education. Laws in Florida and Tennessee went a step further, and they actually trained their caseworkers, remember the sort of gatekeepers at this point, to ask any mother who had been found unfit to receive public aid to voluntarily release their children to a relative or risk referral to juvenile court for child neglect. So the idea was, if a caseworker finds a parent unfit, they have to do something about that. And so let's try and discourage parents from even seeking support to begin with, even staying in the community to begin with, by threatening them with the risk of losing custody if they come to us and seek this support. Okay, so resistance to Brown, in essence, meant resistance to family. Just 6 years later, in 1960, we had 23 states that had new suitable home requirements limiting eligibility for public support. I hope many of you are calling from different states across the country. These are all the states that did have something in place that was passed between that period in time. Again, it's like, is this legal? At this point, we know, right? We just had Brown versus Board of Education. Like, we know about discrimination. We know about fighting these issues. How can this be legal? And there was a lot of challenge that happened, but a lot of it was sort of in the media, and again, like international spotlights on things that were happening in Louisiana is a good example, but there really wasn't. There were no states that lost their ADC support. They all had to continue to provide state plans that continued to be authorized and supported. And it wasn't until 1961 that the head of what was then called HEW and is now our HHS, the head of HHS under President Eisenhower issued a ruling. And this is another place where it's helpful when I have the sort of live audience to say, like, who's heard of the Fleming rule? And we're getting there, like people are hearing it more and more and understanding it a little bit more. But my goal is to really make sure everybody who practices in this space in the United States understands the Fleming rule. And you'll see why in just a second. But Arthur Fleming issued this ruling in January of 1961. For those of you who have ever spent time following presidential transitions of power, I want to emphasize that date because President Kennedy became the president in January of 1961, and the Fleming rule issued the week of the inauguration. Typically, if you feel very strongly about something, you don't issue that as a rule at the tail end of your administration to sort of pass it on to the next administration. But here's what the Fleming rule says. So there's sort of three key parts to it. The first is the rule itself, which is that a state plan may not impose an eligibility condition that would deny assistance with respect to a needy child on the basis that the home conditions in which the child lives are unsuitable while the child continues to reside in the home. So basically saying, like, states, you have to stop with this suitability determination, like these exclusions based on suitability have gotten off the hook. You've got to stop that. That part's good. That makes sense. But then there's these exceptions that were included in the language of the rule as issued. So Fleming says, if the home is deemed unsuitable, public assistance should either be made to improve the home conditions or make arrangements for the child to live elsewhere. So I want you to sit with that, because that's the federal government saying, if you find someone unsuitable to receive public aid, we now want you to either help them out or take their child and have that child live somewhere else. And at the exact same time that the Fleming rule was passed, Congress then decided to provide, for the first time in history, financial support to states for foster care maintenance payments. Initially, this was provided on a temporary basis, but the language used was to provide this support for children who were removed from their parents based on suitability determinations because the parents' immoral or negligent behavior. So, very, very quick happenstance of 1 year without any preparation for this investment of federal funding into the child welfare system. We all of a sudden have suitability determinations become something that you're not allowed to do unless you make arrangements for the child to live elsewhere, and Congress provides funding for states to be reimbursed for making those arrangements. This is the modern day architecture of federal foster care. 1961, the Fleming rule plus Title IV-E foster care funds basically incentivized the use of the other arrangements. And I want to be clear that not all, it wasn't that every child who was removed from a family based on unsuitability determinations was then placed in some kind of formal state-run foster care system. A lot of them, remember Tennessee and Florida, were diverted into relative placements that were not financially supported or reimbursed. But we essentially sort of Fleming essentially incentivized this idea of you can't discriminate with the suitability determinations, but you can continue to discriminate by finding other arrangements for that child. Foster care at this time under federal law essentially became a means of caring for children while denying support, remember our underinvestment theme, for their unfit parents, and went from parents unfit for receiving public aid to that same terminology all of a sudden became parents unfit to parent. And I think it's just a really jarring moment to realize too that this is less than 100 years after the abolition of slavery. And the evidence of the impact of this, because this is sort of also where I feel like sometimes people hear this history and they see these slides and they're like, that can't be, like, why have I never heard this, right? Like, why has this story not been told that much? Why have I not heard of Arthur Fleming? The evidence of impact is extraordinary. So we have, after 1961, the racial identity of children in foster care transformed. Before 1960, there were very few Black children in foster care, in anything that was formally recognized as foster care, because it was primarily administered by state funds and administered through religious organizations. And all of a sudden, after 1961, this sort of concept of caring for children, being able to continue to deny care for parents by caring for children away from their parents, transformed what the racial composition of children in foster care looked like. And AFDC denials became a pipeline for what we now have as foster care, federally funded foster care. Tens of thousands of Black parents lost their children, and Black children lost their parents, kin, and communities in the span of a couple of years. And I just want to emphasize, right, that these are not data, this is not numbers, this is like an entire period of time where a huge impact was felt on individual families, individual children, individual parents. The total number of children in foster care nationally increased by about 67%. And some of the data is a little bit fuzzy on this, but no one questions that there was a huge uptick. And we're going to get to that in a second. There was a huge uptick in entries into foster care between 1961 and 1962. So some of the data that I've had the visual on is that it's about a 67% increase, roughly 90,000 new, additional children entering into foster care system in 1962. And state level data from across the country indicate that by the mid-1960s, about 2/3 of all entries were from families on AFDC public assistance. So I want to go back to that in just a second too. The role of the judiciary is a really important piece of this. And for those of you who are on this call as lawyers or judges, I think this is a really important part to understand, is that there was a backlash, right? Like organizations like the Child Welfare League of America, organizations that were run by social service providers, by caseworkers, were outraged at this. This was not what they wanted to see. They had actually been advocating for federal support for child welfare for years, but not for foster care for years, but not for this. They didn't want foster care payments to be something that would be an alternative to supporting children with their parents based on fitness determinations of ADC. And so their push, and a lot of the national organizations pushed for judicial oversight as the solution, right? Like, okay, the language from a very good book on some of this history is to ensure that rogue caseworkers would not remove children from their homes simply to punish poor mothers for applying for public benefits in the first place. Judges were going to be the stopgap on making sure that that didn't happen. And I always ask, right, like for those of you who know what we operate under today, do you think that the judicial oversight in 1962 worked? It sure didn't, right? Like we had no counsel for parents, no counsel for children. Judges actually often made things worse by not only taking that sort of executive branch removal that was authorized by an agency, but then they added the imprimatur of the judiciary and authorized it sort of with a second layer that became virtually impossible for parents and families to undo. The language that Congress then added, because remember I had said that Congress passed a law that implemented the federal rule, the Fleming rule into law at the same time that they provided federal foster care maintenance payments. Congress then added to that in 1962 to say that states could seek maintenance payment reimbursement after removing a child from a home that was judicially determined to be so unsuitable as to be contrary to the welfare of such child. So we're seeing all that same language. And this is Congress sort of formalizing this stopgap measure that judges are going to solve the problem of caseworkers punishing parents by taking their kids. For those of you who practice in this space today, for those of you who are familiar with these laws, I do think that this is a particularly important comparison slide, is that this is what our law says today. This is what federal law says today. I'm not going to read all of it, but I want you to look at the highlights, right? That Congress provides federal foster care maintenance payments when a child has been removed from the home of a relative, would have been AFDC eligible. For those of you who ever wondered, like, what is that? Why is that connection there? The removal and placement are in accordance with either a voluntary placement agreement, thank you Florida and Tennessee, or a judicial determination to the effect that continuation in the home would be contrary to the welfare of the child, and we now have reasonable efforts would have been made. Same language that we had in 1962. I want you to sit with that for a second. I'm going to pass it over to my co-presenters. I'm just going to go through a couple more final slides here to kind of let you know where we're going. So do any of these terms that have been bolded throughout the presentation sound familiar to those of you who work in this space, either domestically, frankly, or internationally? You know, we've covered best interests, dependent children, casework services, suitable homes, unfit parents, voluntary release, child neglect, immoral or negligent parent, contrary to the welfare. These are all the same terms that we use today. And the origin of them is really, really wrong. Understanding this foundation, understanding the architecture in the law upon which what we operate in today has been built is critical as we navigate where we're going. Because we're here as part of the Kempe Center, I would be remiss if I didn't recognize what also happened in 1962, which was that Dr. Henry Kempe published an article titled The Battered Child Syndrome, recognizing child abuse as a regular and recurring aspect of family life. He argued that a way to break this pattern of indifference toward child abuse was to mandate that certain professionals, primarily medical professionals, report it. And he encouraged professionals in the medical profession to err on the side of child removal to ensure safety, that the bias should be in favor of child safety. I just want to highlight that those same views had actually been around since 1954, and there had been efforts to publish that same article before 1962. And when we've often talked about how this huge uptick, remember I mentioned that those numbers have been uncontroversial, that there was a huge uptick between 1961 and 1962 of children entering foster care. Many times when we've talked about the history before, we've said it was because of this article and because of this sudden awareness that child abuse was a medical syndrome. And I always struggled with that because I'm a good writer and I know lots of good writers, and I've never heard of a published article being like the thing that tips an entire field trajectory into existence. And what I feel like we've now learned is this article came out after that entry into care had already happened. This article came out after the Fleming Rule, after that 90,000 additional children had entered into care. And so I think that this is sort of part of a history that isn't actually accurate in terms of how we say it. So my sort of final message is, and I do this deliberately, I know that sort of in good presentation mode, you're never supposed to have too many things on a slide, but I want you to feel this snowball. I want you to feel this in your gut, that after this period in time, here's where we've gone. Before 1961, remember, there were almost no Black children in foster care, and it was described primarily as a service for parents in need of help. After 1962, when Social Security Act funding had already caused the increase, the Kempe paper came out and called on medical professionals to report for injuries, for physical injuries. State level data indicate, remember I said we were going to come back to this one, that by the 1960s, about 2/3 of all entries were from families on AFDC public assistance and had nothing to do with parental injuries. They were from parents who were found unfit to receive public aid, not because they had done any harm to their children. In 1968, the Supreme Court doubled down on the Fleming Rule in a really important case called King v. Smith, explaining yet again that a parent's welfare application could not justify taking a child. But by that point, so much of the trajectory had been laid. There's a really important piece of academic work that came out from a professor at Howard and UCLA in 1972 that documents, right, just 10 years later, titled Children of the Storm, Black Children and American Child Welfare, that goes into this crisis of removals and impact. 1974, Congress passes CAPTA, requiring mandated reporting, so building on the Kempe idea, but now requiring it of almost every professional who works with children and covering not just concerns about abuse, but neglect as well. By 1977, 1967, 502,000 children were in foster care, a more than 300% increase from 1960. By 1999, that number was up to 567, and close to 40% of all children by 1999 in foster care were Black. Today, Black children have a 50% chance of experiencing a child welfare investigation, and when combined with 2+ races, represent 28% of entries. I know we've made some strides, but this isn't where I think we, any of us, think is appropriate to be. And the final message I'll leave you with is, I know some of the other panels who have been at this presentation have talked about the importance of investing in concrete and economic supports to reduce the need for foster care, and I would challenge us, going back to that Desmond Tutu message about truth and reconciliation, that there's a real irony to that, because I think when we look at this history, we realize that federal foster care was largely created to bypass providing those concrete and economic supports. So suggesting that that's the solution, I think is important, but doesn't tell the full story. And then poverty is not neglect is another message that I know has been reverberating a lot. And I think when we look at this architecture and recognize that it was explicitly built to hold parents accountable for poverty, we really have to wonder, maybe poverty is neglect. It's just that it's not parental neglect. It's our larger social contract that has chosen this sort of dual focus on over surveillance and underinvestment. And Brenda, I will pass it back to you.
So I've been looking at the chat, and someone put a broken heart. Someone else said, wow, it's a lot. And when I first heard this and read the report and talked about it within our commission, it was heartbreaking. And when you think about the why behind Resolution 606 and you look at the history, the connection is very clear. Because laws intentionally were created to ensure that Black families did not remain together. And it really stemmed from economics. It stemmed from I appreciate Prudence tying in the Board of Education case, that because white people didn't want to be educated with Black children. So when you think about all that, and we look at Resolution 606, and you look at the first under further resolve, that first one paragraph, it says to recognize implicit and explicit bias and acknowledge a collective responsibility for challenging laws, policies, and practices that devalue Black families and normalize systemic racism and family separation. This is really the why of us focusing on Resolution 606 and focusing on the Black family. Next slide. And in that why, we faced a lot of obstacles. We faced obstacles within our own commission because some of the commission members just said, you know what, okay, we understand all of what happened, and like the Fleming rule, it wasn't intended to do that, but the impact, so let's move on. And there was even a question, well, why are we separating out Black families? And I appreciate our chair at the time, Judge Gray, said, no, we have to focus on it. And when you look at the history, then you understand why. And it goes all the way back to slavery. But when you look at 1960, how there were hardly any Black families, Black children in child welfare, and then after 1961, the numbers just make it so clear. That's why we have to focus on Black families. And so what we did, it took us 2 years as a commission to get this resolution passed. First, within our own ranks, we had to educate, help people recognize the uncomfortability of what we were facing, the looking at it for themselves and saying, okay, this is a stark reality. And then once we all came together, we said, okay, let's submit the resolution. And do you know that we were told by the calendaring section that puts the resolutions on the calendar that ultimately go to the House of Delegates so everyone can vote on them. They said, no, we're not putting this on. Prudence and a few others were like, what? And Judge Gray said, I don't know if I've ever heard of that before. So we had to meet with some people and find out, so why are you opposed to this resolution? And it came down to us speaking to 3 gentlemen who are somewhat in the higher ranks of the ABA, but they are attorneys who've just been doing this a very long time, involved in the passage of many resolutions. And when we sat with them, it was Judge Gray, myself, and at the time, one of our assistant directors, who's also a woman of color. And we sat with them and said, so tell us why. And so they went back and looked at the resolution and they said, well, first of all, I don't know why you just keep focusing on Black families. You know what, there's no racism. We just need to move on and move forward. Yeah, we know that there was slavery, but we don't need to keep talking about it. And then they were also bothered by the 3rd stanza. If you want to go back for a second to the last slide, Prudence, where the 3rd stanza, where it says in item number 3, consult, listen to, and be led by Black parents, children, and kin with lived experience in child welfare to learn how to support constructive steps to end the legacy of Black family separation under the law. They had a hard time with that. They said, no, we don't think we should be led by Black families. We can talk to them and take their input, but I have a hard time with that. And I couldn't believe it. So I just sat there for a second and one of the gentlemen said, there's no racism. And for a woman of color, first of all, as a person of color and as a woman, I was just like, really? Okay. I was startled, angry. And when we left that Zoom conversation, the 3 of us were just, we were dumbstruck. That's the word I can think of. And we were angry and we were determined at that point. But we were hurt. We were the fight was hard and it was real. So they gave us a lot of good input on how it could get passed, but in the state and in the manner in which it was written, even though they had read the report and saw the connections and had the history, they were like, no. So we went back to the drawing board, we talked to our commission, and thankfully everyone was of the same mindset that we were going to move forward. And we did. And but we had to work through our own internal issues. And so we use this next slide as kind of a diagram of what we had to work through, but what we also had to help other people work through. And most of all was that this was an uncomfortable subject and that people had to be uncomfortable with the fact that it was uncomfortable and asking themselves, well, how do I talk about racism? Am I a racist? That's when all the books were coming out about racism and, white fragility and just different things where people were having to focus on themselves. And it was a difficult time, but we had to keep focusing on the fact that there was racism and existed for Black families. So thankfully, we worked through it. And when we did finally get there, we realized there's just a lot of lessons that we learned and that we had to help other people recognize. And the biggest one is sometimes you just need to understand where the origin of the laws, where they begin and the impact, and not necessarily the impact always isn't what was intended, but it ends up what's happened. And so, but if that's not challenged, then we continue in the same cycles. And that anti-Black racism and child welfare is not unique. Unfortunately, it's systemic and it's pervasive. And we have to acknowledge, appreciate, and welcome the culture, race, identity of different people, the value of who they are, the humanity of who they are in our child welfare cases. And that often gets lost because sometimes the savior syndrome takes over and people feel that they need to change someone in order for them to fit their mold. But we really have to respect that and recognize it. And that the biggest part of this that we learned as a commission is that we have to allow ourselves to be led by those who have been in this system. And we have to listen to their voices. And that's what we kept telling these men that we were sitting there with, is that you have to let Black families lead because they know what they need. You don't. And so there are a lot of lessons that we learned from this process. And so we are calling on legal professionals to end the legacy of Black family separation. And so with that, I'm going to pass it over to Keisha so that she can bring us home.
Good afternoon. I'm just going to start off by just saying that, or I guess seeking permission to just come very authentically. I think I had a presentation prepared and there's just a lot that has come up for me during this presentation. I want to give us all permission to take a collective pause in this moment. We've just heard a lot of information. Some of us may have heard this information before, maybe packaged differently, or maybe there's parts of this. I think I saw someone in the chat saying they had no idea. And so I want to give us permission just to take a collective pause and to really appreciate, recognize whatever feelings are coming up for you in this moment, whatever physiological responses you are having to the information that has been presented today, and give us permission to just feel through that and to sit with that. So I wanted to do that to ground us. There's a couple of things I want to do to ground us this afternoon as we move into where do we go from here. For some of us, as we were listening to this information today, and if it was a learning opportunity, we may have felt emotions of anger. I know I did. We may have felt emotions of shock. We may have felt guilt. We may have felt shame. And we also may have felt hope, whatever emotion that came up for you. And I want to just share just personally, as someone who comes to this panel, as someone with lived experience in the system. My family was impacted by the violence that we heard about today, and is still being impacted by the violence that we heard today. And also as someone who has the privilege of walking with families every day who are experiencing the violence of the system. That as I was aging out of the system and trying to reconcile my own journey reconcile why I and my siblings were the top of our family tree, I had the gift of picking up a book called Shattered Bonds. And in that book, some of you on this call may have read it. She talks about some of the history that we talked about today, some of the information that we talked about today. And I'm very careful to say that because I think while what we learned today, the foundations, right, the historical roots are historical, the reality is that this isn't history. This is what is currently. This is what families in this country are continuing to experience. These laws have not been repealed. And the impact that this has, I think sometimes we think about just the immediate separation between children and their parents, but it has generational impacts, such that at the age of 18, I'm reconciling with why am I the top of my family tree? But in the book Shattered Bonds and learning about this history, and I think the gift that we also have today and sitting through this presentation is that now that we know, we can do better. We can. And I don't know, and I told Brenda and Prudence this, prior to reviewing Resolution 606, so I actually came in onto the commission the second year that Resolution 606 was being worked on by the commission. And immediately, Prudence and Nadia put me to work and asked me to work on just reviewing it in general, but also really taking a look at the third section on being led by folks with lived experience in the system. I had never seen this history laid out in this way that was so comprehensible, that didn't make me feel like this is a conspiracy theory, right? It was just laid out so, I think, succinctly and comprehensively. And so between those two pieces of work, right, Shattered Bonds, ABA Resolution 606, it has actually been really the catalyst to my healing journey. Because it was for the first time when I picked up Shattered Bonds that I was able to disconnect from, or at least reframe, my own personal experience as one that didn't just happen to me and my family, but something that was actually intentional and rooted. And as a consequence, that gave me hope that there could be change, right? So that my children and my children's children and future children's of Black families will not have to experience the violence of this system. And so I want us, if we felt any type of, I guess what I would characterize as like a negative type of emotion, the hope that I hope that I'm trying to say and share with you all today is that we can collectively in this room stop this violence. The other thing that I want to do to ground us for the conversation about what is next is I want us to take a moment to think about our own relationships. And we're going to go back to the blank slide. This is again in presentation. I don't want us reading that slide right now, but I want us to all take a moment and think about our relationship with our parents or our relationship with our own children. And what comes up for you. And here I'm going to do something interactive, partly because I know it's late in the day here. It's probably, we've been sitting through an hour-long presentation thus far. To drop into the chat, what comes up for you when you think about your relationship with your parent, or you think about your relationship with your own child? And I'll give us a moment just to drop it into the chat. I think that one of the things that we have to do to ground ourselves again for this conversation is to understand and to appreciate the sacredness of that familial bond, right? Such that we wouldn't pass laws that just because we don't want our children to go to school with a Black child, that we would literally destroy entire bloodlines, entire communities. And still, again, in 2023, as we are sitting here today, still have those laws on the books. If we're thinking about sacred family, we're thinking about that bond being sacred and precious, that every Black boy, every Black girl, every Black child deserves to have that bond preserved and protected and respected, we wouldn't have questions about why. We need to speak to those who have been impacted by this violence to determine how we move forward. And so now I do want to talk about Resolution 606, and specifically the third resolution on page 1, which, as Brenda indicated, was something that we talked about as a commission. And we didn't just get pushback, let's be clear, from outside folks. We also had some pushback within our commission as well. But one of the beautiful things that I felt like happened as I was sitting there and participating in that meeting was that we as a commission committed to not putting forth something before the commission that took out the spirit of what it was that we were trying to get passed, right? And so we said, you know what? If the resolution fails, it'll fail, but not because we decided to water it down. And so what Resolution 606, the third part of the resolution, says is that as legal professionals, and I really want to just say too, I know we say legal professionals, but there's so many other professionals that are connected, right, with this violence that's happening with our families: medical professionals, education, law enforcement, right? That's complicit as well with what has occurred and what is occurring to Black families. But what we're calling on is for a community, really, for us as a community to value the sacred bonds of Black families by consulting with, listening to, and being led by Black parents, children, and kin with lived experience in the system to learn how to support constructive steps to end the legacy of Black separation under the law. And I want to be clear, even though the resolution is calling for just separation, the violence isn't just in the moment of separation. The violence is in the over surveillance of our families. It is in the investigations, right? It is in the aftermath of the tools and the resources that are not provided to families after you have caused them to have this traumatic experience, and then have the nerve to put families back together and not give them the resources to be able to heal from that trauma. So as a community, we have to end that, because it doesn't just, again, impact a single family. It is destroying, it's genocide. That is what it is. It is genocide of the Black community. The more we continue to fray our families are the foundation. They are the bedrock. They are the strength of our communities. And this system has been complicit in continuing to break down that foundation, again, by design. We looked at the history that was the design and the purpose of separating families, and even having the threat of separation of families when we were brought here to this country. So the other things that this resolution calls for, if we can go to the next slide, is what is our role? Where do we go from here? Well, first, it is respecting and honoring and protecting, again, that sacred family bonds. I think that's the core. And in doing that, we would respect the families, right? And in respecting families, that's respecting the agency of the parents to be able to raise their children without having government surveillance, without the, because again, in 1960, we weren't even allowed to participate. So what were we doing before 1960? Taking care of our children. Did we have crisis within our community? Absolutely. But as a community, what our values are is that we as a village take care of one another without the violence that this system imparts. I have aunties and uncles from my foster side of my family who had to raise younger siblings or other members of the family for a short period of time, but it wasn't violent. And what this system is violent. Also, just for this first prong about respecting family, just low-hanging fruit that I want to just impart for all of us who are working with and have the privilege of working with families is that we call people by their names that they prefer. Can we all commit today to stop referring to a mother as mother versus her preferred name, a father as father versus his preferred name, a child instead of foster youth, or referring to them as the minor? Can we give them the respect? It doesn't take much more time to say their name. That's respect, and that's dignity. Supporting families with family-centered services. Again, I'm going to piggyback this on with D, right? Or really it's C and D. I messed up the order. But we cannot presuppose that our families need our intervention. I think we have to start there. This system, I think, starts with we have to intervene in order to help you to be able to function. At least that's what's said, right? So again, not intervening where folks don't need to be intervened with, asking them if they need anything, and not penalizing a parent when they say, I don't need your support and help. Some of us have experienced social workers saying to a parent during an investigation phase, if you do X, Y, and Z, we will not file a petition. And a parent saying, I don't need those services that you're offering me. My family is fine. And then having a social worker file a petition on that basis and a judge rubber stamping that. We have to stop doing that. Parents can and children being experts of what their family needs are, right? Again, not presupposing that our families don't already have the strength, our own strengths that we need to have the government intervening, which, by the way, the government's intervention is not resulting in good outcomes for the children who you say that you're intervening for. A majority of us who have had to experience the violence of being separated from our families are not, we feel like we talk about having exited the system as surviving, emancipating out of the system. Checking our own implicit biases. Again, I've already talked about this, but every removal is a family separation. But again, going further, every government intervention into our families is violent. And when it's not necessary, which in most cases it's not, the government should not be putting that trauma and that violence onto our families. And then lastly, just thinking about the intent and the impact. So we've talked about today, I think it's clear there's some of this, some of the legislation, some of the laws that we talked about today, that it was intentional. And then I know that there's some of you sitting in this room who heard about some legislation that you think maybe wasn't intentional, right? But the call that I would make and what I would invite us all to do is to think about what the impact of these laws are. So whether you believe it was intentional or whether you believe that it was well-meaning, if the impact is destroying, right? Destroying entire generations, right? The number one indicator of whether or not a child is going to go into the system is if their parent was in the system. It is a cyclical generational impact that impacts the entire, I don't know how to convey that. But I wouldn't wish it on my worst enemy to be disconnected from the bloodline in the way that my family has been disconnected. And when I learned about and I heard about this history, I was angry. My first response was anger. Because it doesn't have to be. And so if each and every one of us in learning this history, right, and going to the quote that Prudence raised with us earlier today, if we can learn about this history, right, then we can collectively ensure, because we really can ensure, that this violence doesn't continue to happen and doesn't continue to be perpetuated. We can go to the next slide. So I just want to highlight really quickly, and I know just in the interest of time, I'm not going to read through all of this. And I think that what Prudence is going to do is make sure that everyone has a copy of this article that was written by one of our colleagues, Joyce McMillan and Angela Burton, who did a really amazing job on really articulating how our judicial officers can ensure and promote essentially embodying what we are trying to embody with Resolution 606. But before we go there really quickly, the one thing I just want to highlight though to judges who are in this room is that there are parents in this country who are really trying to protect their families, protect our communities by saying to social workers, I will not allow for you to come into my home and do a search of my home if there's not probable cause and a warrant to come into my home. There are parents in this country who are saying, no, you cannot strip search my child. There are parents in this country who are saying, we have within our community the resources to take care of our children. We do not want the government to intervene. And when parents speak up and they say that, and a social worker submits a probable cause declaration, and the probable cause is that the parent is exercising their constitutional rights, we have to stop granting those warrants. And we have to stop punishing and penalizing parents when they come into court and you say that they're being uncooperative because they're exercising their constitutional rights to the care, custody, and control of their children, and to stand in their Fourth Amendment rights. This is another way that we can stop and we can actually embody what we're trying to embody with Resolution 606. Next slide. This was the quote I was trying to reference earlier, which is that we learn from history, that we don't learn from history, and that we all collectively have the chance. And that's what's exciting, to break this cycle, to stop this violence. Next slide. So what I want to invite us all to do is to envision how we're going to use this information from Resolution 606 in our own individual roles to combat racism within this system. And if you could just drop into the chat, because we don't have, again, we're not in person, the commitment that you're going to make today. Maybe it's going to be something that I gave you already as low-hanging fruit. Like, I will refer to my client by the name that they prefer. Because even in that, humanizing your client, I promise you it'll change the way that you advocate on behalf of that family. It'll change the way when you're sitting as a judge that you make decisions concerning that family, because you won't see them as just another mother, father. You're going to see them as a human being and treat them accordingly and protect that sacred family bond. I'm just going to read off what some people are dropping into the chat. Looking at the family as unique. I love that. There's a conference in 2 days that Richard is giving in regards to just, again, more education. The more we educate ourselves, the more we can unlearn, right? And we can come up and we can reimagine ways that we can better serve our families. There's another session tomorrow on the Fourth Amendment that Joyce McMillan is hosting. I will be in the room. Dignity and respect. Having conversations about healing. Someone talked about white privilege and the importance of universal education. I also want to just pause here too, just to say that sometimes when we hear histories, it could become more palatable depending on who's delivering the message. And so one of the things that I, again, want to just highlight about my experience on the commission is that our leader, Prudence, really has embodied Resolution 606, even before the resolution got passed. And when we were sitting in rooms, I noticed, and I don't know if you noticed that, I noticed this, Prudence, but when there's things that were spoken into the space by folks that had lived experience that are on the commission, Prudence would be over here, like just making sure that that point got across and really championing the point. And so sometimes it is ceding power, right? Or using your power to really highlight the voices of those with lived experience if you don't personally have your own lived experience. So with that, again, I hope that my conversation today, again, wanting to be authentic, but also not wanting to alienate anyone, and also wanting to leave us with some hope that we can change and we don't have to look. Some of us have been doing this for 20, 30 years, and we've heard this before. And some of us have lost hope. And so I'm hoping that in this Resolution 606, the more that people that hear about it, that it will reignite our community to change.
Wow, thank you, Keisha. And we're out of time, but I just hope that you're able to get some time away and just sit with this. And as you sit, commit yourself to what you are going to do. And please share this information. We really want to thank you. We appreciate your attention. All the comments in the chat, I copied them all and I have them on an email to send to my two co-presenters. But we hope that this will give you hope, but most of all, just give you a resolve, reignite you to continue to do the work. Thank you very much.